Welcome to the Deep Dive. We're the show that helps you get instantly well-informed on complex topics. So imagine this for a second. Someone else has access to your money. Could be your investments, your savings, really your future. How do you know, really know that they're acting in your best interest and not, their own? That question. That's basically what we're digging into today. We're exploring this crucial, often kind of invisible world of financial rules, regulations designed specifically to safeguard your accounts and, keep the finance industry honest. Our deep dive is pulling from a collection of essential guidelines, specifically drawing from a key document called Safeguarding Accounts, Rules and Regulations in Finance. And our mission here is simple. Cut through the jargon, show you the rules that actually protect you as an investor, and make sure things are fair. We think we'll uncover some surprising things, stuff that really matters for your financial peace of mind, so let's unpack it. All right, let's kick off with the principle that when you first hear it might sound a bit radical. Generally, employees of financial firms, they are prohibited.
They cannot share in the profits or losses from their customer accounts.
That's right. And it sounds basic, but it's foundational.
Yeah, think about it. Your advisor, the person you trust, may be nudging you towards something because they get a piece of the action. This rule is meant to just stop that cold. What's the core idea?
The core idea is purely about aligning interests. You need your financial pro acting only for you, not looking for a personal cut of your gains or worrying about your losses hitting their own pocket. That alignment, that's what builds trust. But what's really interesting are the specific exceptions, very specific.
Okay.
For instance, an employee can share, potentially if they've put their own money into your account, a real contribution, and then they share proportionally.
Proportionally to what they put in.
Exactly. But here's the big hurdle. It requires prior written consent from you, the customer, and from their own firm. No informal agreements. It has to be documented up front.
Got it. Written consent. Are there other ways?
Yeah, a couple more key exceptions. That proportionality thing doesn't apply for immediate family. So maybe a joint account with a spouse or a parent. Sharing's allowed there without that strict contribution matching.
Okay, that makes sense for families.
Right. And then there's a special case, investment advisory accounts. These are usually fee-based, not commission-based. Here, sharing is also possible, but again, only with prior written consent from both you and the firm. And the firm has to follow specific SEC rules for advisors.
So transparency and explicit permission seem to be the themes.
Absolutely. It's all about clear lines and formal agreements.
Okay, sticking with clear lines, let's talk risk. Investing has risk, obviously. So financial professionals are also strictly banned from guaranteeing you against losses or promising to pay you back if an investment goes south. Now, to someone new to investing, that might sound a bit harsh. Why is that rule so absolute? What's the reasoning?
That's a really important question. It cuts right to the reality of investing. This rule, it's essential to make sure you, the customer, understand and accept the risks involved. It's your money, your risk. Think about it. If your advisor could just promise you can't lose money, it creates this false safety net, right?
Yeah, you might take on way more risk than you should.
Exactly. It would totally distort the whole picture of investing. Markets go up, markets go down. You need to understand that risk yourself, not rely on some personal guarantee from your advisor. That's just not how it works.
Right. It prevents misrepresentation, keeps things grounded in reality. Okay, let's shift gears to something that might genuinely surprise some people. Can your financial advisor lend you money? Or can you lend them money? You might think, well, if we trust each other, why not? But the rules are pretty clear, aren't they?
They are very clear. Generally, registered representatives are strictly prohibited from borrowing from or lending to a customer, full stop.
Why is that line so bright?
Because it just muddies the waters so badly. It creates huge potential conflicts of interest, even more than the profit sharing we just talked about. If your advisor owes you money, how objective can their advice possibly be? Or vice versa.
Yeah, I see that. But you said generally, so are there loopholes or permitted circumstances?
There are. Not loopholes exactly, but very specific controlled circumstances. These practices can be permitted, but only if the firm itself has written procedures allowing it and at least one of 5 specific conditions is met.
Okay, what are these 5 conditions?
Well, the first 2 are kind of the obvious ones. 1, if you, the customer, and the rep are immediate family members, makes sense. 2, if you, the customer, are actually a financial institution yourself, like a bank that regularly makes loans. That's your business.
Right, those seem logical. What about the other 3?
Okay, these get a bit more nuanced. Condition 3, if both you and the rep are registered with the same firm. Condition 4, if the loan is based on a personal relationship outside of the advisor-client one, like your college roommates or your neighbor, something totally separate.
A real personal connection, not just the business one.
Exactly. And fifth, if the loan is based on a business relationship that's also independent of the customer-broker relationship, maybe you co-own a restaurant together, completely unrelated to your investments.
Okay, so very specific situations. But even for those last three, same firm, personal relationship, independent business, I imagine there's still oversight needed. It sounds like it could still get messy.
You're absolutely right to ask about oversight. It's critical. For those last three conditions, same firm, personal, or separate business relationship, the registered person has to notify their firm before anything happens, before the loan or borrowing arrangement starts.
Just notify or get permission.
Get permission. The firm's role is vital here. They must provide written pre-approval. They have to look at it, sign off on it, and they have to keep records of these approvals for at least 3 years after the arrangement ends. If the rep leaves the firm, they still keep the records for 3 years after termination.
Wow.
Yeah. It ensures there's a clear paper trail. It's all about transparency, accountability, protecting the firm, and ultimately protecting you, the client.
That level of scrutiny.
Yeah.
It really is reassuring. Okay, moving from potential conflicts to actively protecting vulnerable clients. This is a big one. Financial exploitation, especially of older adults, is a growing concern, and FINRA, the Financial Industry Regulatory Authority, has really focused on this. They even set up a hotline for seniors, which helps lead to a specific rule, FINRA Rule 2165.
Yes. Rule 2165 is incredibly important. It gives firms actual tools to intervene if they suspect something's wrong. The rule defines a specified adult. It's quite broad. First, anyone aged 65 or older, simple enough. But second, it also includes anyone aged 18 or older if the firm reasonably believes they have some mental or physical impairment that stops them from protecting their own interests.
How do they determine that reasonable belief?
It's based on the facts and circumstances, what the firm observes in their interactions, communications, things like that. It's not a medical diagnosis, but a practical assessment based on interaction. And to help firms protect these individuals, the rule brought in the idea of a trusted contact person.
I think I've been asked for that on account forms.
Exactly. This person has to be 18 or older, and their role is basically to be a point of contact if the firm has concerns about potential financial exploitation or maybe just your health status. Firms are encouraged to make reasonable efforts to get this info name, contact details when you open or update an account. It's not mandatory to open the account, but it's strongly encouraged. It gives the firm someone to reach out to.
Okay, so we have the specified adult and the trusted contact. What exactly counts as financial exploitation under these rules? What triggers the alarms?
FERE's definition is pretty thorough. It includes the wrongful or unauthorized taking, withholding, appropriation, or use of a specified adult's funds or securities. Pretty clear theft or misuse, but it also covers any act or omission by any person, even someone who legally has power of attorney or guardianship if they use deception, intimidation, undue influence, or just convert assets to gain control over the specified adult's money or property for their own benefit.
So it's not just stealing, it could be manipulation or misuse of legal authority too.
Precisely. It's broad to capture various forms of abuse.
And one of the key tools Rule 2165 gives firms is the temporary hold, right? Can you explain how that works?
Yes, the temporary hold is a crucial protective measure. But it's important to be clear. It's a hold on the disbursement of funds or securities out of the account, getting money out.
So it doesn't stop trading within the account.
Correct. It doesn't block securities transactions like buying or selling stock. It stops the money or assets from leaving the account if exploitation is suspected. This hold can apply when, say, proceeds from selling stock are requested to be sent to someone else and the firm suspects foul play, or for single large withdrawals or a request to transfer the entire account somewhere else using ACATS.
What's ACATS again?
Oh, sorry. That's the Automated Customer Account Transfer Service. It's the standard system brokerages use to move a whole account smoothly from one firm to another. And crucially, the hold can even apply to moving assets between accounts at the same firm if exploitation seems likely, like trying to move funds from grandma's account to a relative's account at the same brokerage.
But not routine stuff, like paying bills.
Generally, no, unless the firm has a reasonable belief that that specific bill payment is part of the exploitation. But for normal, recurring bills where there's no suspicion, the hold typically wouldn't apply. It targets suspicious outflows.
Okay, so if a firm does place a hold, what happens next? What are their obligations?
They have to act fast. First, they must promptly start an internal review, look into the facts, why they suspected exploitation, and then notification. Within about 2 business days, they need to notify, orally or in writing, all the people authorized to transact on the account and the trusted contact person if one was provided.
Telling them about the hold and why.
Yes. Unless, and this is important, the firm reasonably believes one of those authorized people, or even the trusted contact, is actually the one doing the exploiting. You don't want to tip off the potential abuser.
Right, that makes sense.
And the rule also encourages firms to try and talk to the customer first, if possible, before placing the hold to resolve the concern. If a hold is placed, it can only be lifted after they've contacted the customer or the trusted contact to discuss it.
How long can this hold stay in place? Is it indefinite?
No, definitely not indefinite. There's a time limit. The initial hold can last for no later than 15 business days.
Okay, 3 weeks, basically.
Right. But if the firm's internal review backs up their initial suspicion, they still reasonably believe exploitation is happening or being attempted enough, they can extend that hold for an additional 10 business days.
So potentially up to 25 business days total.
Correct. Or it could be extended or terminated earlier by a regulator or a court order. It's designed as a temporary pause, a window for investigation and intervention, balancing protection with the client's access to their funds.
That's a really important protection. Okay, let's shift perspective a bit. We've talked about rules protecting customers. What about rules for the financial professionals themselves, specifically their own personal accounts, even ones held outside their employing firm? It sounds a bit like Big Brother. But firms actually have to monitor these away accounts, don't they? Why?
They do, yes. And it's primarily about managing conflicts of interest and preventing things like insider trading or front-running customer orders. If an employee knows a big client order is coming, they shouldn't be able to jump ahead in their personal account at another firm, right?
Makes sense. So what counts as a financial institution here? Just other brokerages?
It's broader than that. It includes other broker-dealers, sure, but also investment advisors, banks, insurance companies, trust companies, investment companies, basically anywhere you could potentially trade securities.
And what does the employee have to do if they want to open such an account?
The requirements are pretty strict. First, they need prior written consent from their own employing firm before the account is even opened. Second, they also have to tell the executing firm the place where they're opening the account in writing that they're associated with another member firm. Again, before the account is opened.
What if they already had the account before starting the job?
Good question. If the account existed before they joined the broker-dealer, they usually have about 30 days to get that written consent from their new employer to keep the account. And they still have to notify the executing firm about their new employment.
Okay, and this isn't just about the employee's own name on the account, is it? Does it cover family members too?
Yes, it extends quite broadly. The rules apply to any account where the employee has what's called a beneficial interest or control, and through which securities transactions can happen. So that typically includes accounts of their spouse, their children, especially if living with them, or financially dependent, or any other related person whose account they control, or even someone they materially contribute financial support to if they also have control over that person's account.
So it casts a wide net to capture potential conflicts. What about the firm where the account is actually held? The executing firm, what's their role in this monitoring?
Their main obligation is transparency back to the employer. The executing broker-dealer must provide duplicate copies of confirmations, account statements, basically any transaction information directly to the employee's employing firm, if the employing firm requests it in writing.
So the employer can actually see the trading activity.
Exactly. It allows for proper supervision. Now, there are some exemptions. This rule generally doesn't apply to accounts limited only to certain types of investments, like mutual funds, unit investment trusts, UITs, variable annuities or life insurance, or 520 name plans.
Why exempt those?
Usually because those types of investments are less susceptible to the kind of rapid trading or insider information concerns that the rule is designed to prevent. They're typically longer-term vehicles.
Okay, that clarifies the scope. Now, sticking with internal integrity, can a brokerage firm pay someone, like for referrals or business, if that person isn't properly registered? Seems like a clear no, but what's the rule?
It is a clear no, and it's fundamental. You cannot pay transaction-based compensation commissions, finder's fees, referral fees tied to deals, discounts, concessions to any unregistered broker-dealer or any person who isn't properly registered as required.
Why is that so strict?
It's about maintaining the integrity of the registration system. Licensing and registration ensure that people involved in securities transactions meet certain standards of knowledge, ethics, and are subject to regulatory oversight. Paying unregistered individuals undermines that whole system.
But is there any exception? I think I heard something about retiring brokers.
Ah, yes. There's a very specific, interesting exception for retiring representatives. A firm can continue to pay commissions to a retiring rep, but only for existing accounts that they serviced. But there has to be a bona fide written contract in place before they retire detailing this arrangement. And crucially, that contract must explicitly prohibit the retired rep from soliciting any new business, opening new accounts, or servicing the accounts in any way. They're basically just receiving trailing commissions on work already done.
So it's a very narrow path for retirement income, not a way to keep doing business unregistered.
Precisely. It allows for a structured retirement payout from past efforts, but cuts off any ongoing activity that would require registration.
Got it. And one last point on integrity here, something really serious. Forgery. We know what basic forgery is, signing someone else's name. But you mentioned something called technical forgery. What's that? Sounds less malicious, maybe.
It often is less malicious in intent, but it's still a very serious violation. Forgery, generally, is signing another person's name without any authorization. Clear fraud. Technical forgery usually happens when a representative signs a client's name to a document, maybe thinking they're being helpful, or because the client said something like, "Oh, just sign it for me over the phone." They believe they have authorization, but it's not the proper documented authorization, like a written power of attorney.
So even if the client verbally said, okay,
Even then, without the correct, usually written authorization specific to that action or document type, signing for the client is still considered forgery. Even if the rep had good intentions, like speeding up a transaction the client wanted, it violates rules about proper authorization and documentation. The consequences can be severe.
that's a really important distinction. Okay, all these rules about conduct, monitoring, authorization, they all really rely on one foundational thing: good records.
Which brings us to record keeping. We know firms have to keep records for years, but let's talk about how they keep them, the formats and safeguards, especially now in the digital age.
Absolutely. Record keeping is the bedrock of oversight and accountability. You can't enforce rules if you don't have the records to prove what happened. And yes, while paper is the old school way, regulators like the SEC have long permitted other formats. Micrographic media, think microfilm or microfiche, basically tiny photographic copies, and of course, electronic storage media, servers, cloud storage, CD-ROMs back in the day. Okay, so if a firm goes digital, which most probably do now, what are the requirements? It can't just be saving files to a regular computer, right? The integrity has to be rock solid.
Definitely not just any computer file. The SEC rules for electronic storage are very specific and demanding, designed to ensure the records are authentic, accessible, and unalterable. First off, a firm has to notify its main regulator, its DEA or designated examining authority, before it even starts using electronic storage for the first time. And if they change the type of electronic media later, they need to give 90 days notice.
So upfront notification. What about the storage itself?
The records must be kept in a format that is non-rewritable and non-erasable, often called worm write once, read many, like burning a CDR back in the day. Once it's written, you can't change it.
Immutable records.
Exactly. The system also has to automatically verify the quality and accuracy of the recording process. And the records need to be serialized, like numbered pages, often with time and date stamps for when they were created or stored.
What about getting the records out if regulators need them?
That's critical. The firm has to be able to easily download both the records themselves and any indexes for those records onto any medium that the SEC or the SROs like FINRA accept. They need to be readily accessible. And crucially, there must be a place where regulators can easily and promptly access and review the stored records. Plus, the firm has to maintain duplicate copies of the records stored separately, maybe geographically separate from the originals. Same for the indexes, duplicates stored separately.
Wow, redundancy built in everywhere. Non-erasable format, verified recording, easy download, separate duplicates. That sounds incredibly thorough.
It has to be. It ensures that records can't be tampered with, lost in a disaster, or hidden from regulators.
And I know FINRA, with its Rule 4511, and the MSRB for municipal securities, with Rules G8 and G9, they also have their own specific record-keeping requirements, right? Covering documents maybe not explicitly covered by the SEC.
That's correct. There's often overlap, but also specific rules from different regulators ensuring all the necessary documentation across the business is captured and maintained properly. The goal is always the same: complete, unalterable, accessible records. It protects the firm with a clear audit trail, And it protects you, the investor, by ensuring transparency and accountability. It truly is the backbone of trust.
So, wrapping this up, what does all this mean for you listening right now? We've covered a lot of ground, from who can share in your account's profits or losses, the strict rules on borrowing and lending, those vital protections against exploiting vulnerable adults, how even your advisor's personal accounts are watched, and these really rigorous standards for keeping records.
Mm-hmm.
Understanding these rules, even though they seem complex or maybe behind the scenes, isn't just academic. It really creates a safer, more transparent financial world for everyone.
Yeah, these aren't just abstract regulations, they're concrete protections.
Exactly. They're the foundation of trust that should give you more confidence when you're navigating your own financial life.
And maybe it leaves us with a thought to ponder, right? As technology keeps changing everything in finance, we've got AI advisors now, new digital assets popping up. What's next? What's the next frontier for regulation look like? What new rules will be needed down the road to make sure your interests are protected and the markets stay fair and reliable in this rapidly evolving landscape? Something to think about.